So some examples, looking back over my visits to Day on the Hill and the Capitol Summit up in D.C., some examples of how our advocacy has helped shape legislation. Many of you probably remember back in 2023 there was House Bill 1417. It was commonly called the preemption bill, and this was signed into law by Governor DeSantis, and it went effective July 1, 2023, and it created Florida Statute 83.425 to preempt the regulation of residential tenancies and landlord-tenant relationships to the state. It nullified over 40 local tenant protection ordinances, including rent stabilization, rent control, and the Tenant Bill of Rights measures in various counties that created varying and often conflicting regulatory requirements for property managers. All of you who manage in this local market right here probably remember, in Orange County they had a Tenant Bill of Rights, and it required a 60-day notice if you wanted to raise the rent more than 5%. It required a 60-day notice of lease termination, even if you were on a verbal month-to-month tenancy. Now, at the time, Florida statute only required a 15-day notice of termination if you were on a verbal month-to-month tenancy. This ordinance that went into effect in Orange County bumped that all the way up to a 60-day notice. When the preemption bill finally got passed onto the state level, they sort of engaged in a compromise and settled on a 30-day notice, regardless of whether you were on a written lease or a verbal month-to-month lease. They also established source of income protections and mandatory upfront disclosures of all potential fees that an applicant might be obligated for under the terms of the lease. The source of income protection was a big one, because depending on what county you were in this case in Orange County, that meant if you didn't participate in Section 8, you were now mandated to. But in Orange County, they required an office to be certified before you can even participate in Section 8. So it created these conflicting regulatory burdens whether you wanted to participate or not. So the passage of House Bill 1417 up on the state level was a big, big win for property management, and it created a more level and consistent playing field, which we're all happy about. Another win for us. House Bill, this happened in 2024, and it was House Bill 621. It was colloquially called the Squatters Bill. And property managers or property owners could request local sheriffs to remove unauthorized individuals immediately rather than having to file an eviction or an ejectment action in civil court. And I'll give you two perspectives on this bill from personal experience. Before this bill passed, I had one of my property managers on my team called me up. He had gone out to show the property, and when he got there was a car parked in the driveway, and there were people inside. And the first thing he did was call me. And he said, what am I going to do? I can't get in, obviously. The lockbox is broken off the door. There's people inside. And I said, well, you got to call the police, which he did. Now, at the time, before the squatters bill had passed, the police could take a couple of different approaches to this. They could say, this is not our problem, this is a civil issue, and if you want to get rid of them, you have to file an eviction action or an ejectment action. There's nothing we can do. Luckily, the cops that were dispatched took a little bit of a different approach, and they said, well, there's nothing legally that we can do here because it is technically a civil action, but we can try and convince these people to leave. When they arrived, the property manager and I had showed them proof that we're the property management company. It's currently advertised. We don't have a lease in place. So thankfully to them, they said, we'll try and convince these people that they need to go. And through a lot of negotiation, they ultimately were able to convince these people to go. And the only thing that these people who were in the house illegally asked for was 20 minutes to pack up all their belongings and move them outside. So my property manager and I and the cops stood outside in front of the garage while the illegal people in the house spent the next 20 to 30 minutes vandalizing the inside of the house while they packed up their stuff. And then they hit the road. And again, this was a civil issue, so there was nothing that the cops could do. So we were pretty, and to make matters worse, this is sort of insult to injury. The owner of this property had just spent $10,000 completely renovating the inside of the house with new kitchen, new bathroom, new paint, new flooring. And these people had had their kids go and graffiti all over the walls. I mean, it was still fresh. You could see it on the walls. In the short amount of time they had been in the house, they had damaged the bathroom cabinets. They had damaged the brand new kitchen cabinets. So it took another several $1,000s to repair all of this damage and get the property ready to rent again. So that's one side. That's the pre-squatters bill. Second example is after the squatters bill passed. And coincidentally, it just happened to be the same property manager in my office was going to take his pre-move-in photo documentation. He had a signed lease, and the people were supposed to take possession that day. He went there first thing in the morning, and he walked into the house. Luckily, there was nobody there, but there was clothes, a little bit of furniture, all kinds of personal belongings in the master bedroom. And so, of course, he called me again. Said, I got another situation here. Yes, and what did I say? Call the cops. So the cops showed up, and luckily, they were already aware of the passage of this squatters bill. So it was kind of remarkable, the difference in approach. While I appreciate the approach of the first set of cops on this other one, because they didn't have a legal obligation to do anything, this time around, the cops showed up in force. I think there was 5 cop cars that showed up, and the first thing they did was go and clear the house. They walked through, make sure nobody was there, and then they immediately said, you can start moving all of this plunder out by the side of the road. And so we started doing that because we needed to deliver possession of the property to another tenant. And in the course of moving all of this stuff out to the side of the road, the cops were kind of looking at it, and they saw some paperwork, and they picked it up, and they go, oh, we know this person. We've had lots and lots of experiences with this person. And so they knew this person so much, they even had contact info for this person. And so they called them. And of course, we got the same old sob story. Oh, I have a lease agreement. Oh, I paid all kinds of money. Oh, I paid a big security deposit. Oh, I'm at work. I can't get away. But at the end of the day, because of the passage of this squatters bill, we were able to just move all of that plunder out by the side of the road. We rekeyed the locks again. Luckily, no damage had been done, and we were able to deliver possession on schedule. So that's the passage of the squatters bill is directly the result of advocacy on the state level at Day on the Hill. So that's a big win for us. I think the most recent one that we have here, a big win for us based on long efforts in advocacy spanning years and years and years, is the electronic delivery of notices bill. That was House Bill 615, and that went into effect July 1 of 2025. So it's not even a year old yet. But that authorizes electronic delivery of notices required under the terms of the lease agreement, 3-day notice, 7-day notices, security deposit claim notices, etc. That's been a big win for us, and that seems to be nearly universally not only accepted but liked by our tenants. We've had one tenant who opted out, and when the property manager contacted her to confirm, she said, oh, I don't know why in the world I did that. That was a mistake. Please send me another one and I'll opt in. So it's been a great win for us.